your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I fix you up for you.
Well, welcome to the show. Today is a new judge that I just stumbled across when I was doing my research. This is Judge Vonda Bailey. So let's get this party started. And let's make this bigger.
5006. Councils, will you please announce for the record?
Abby Ewing and Stephanie Mathern on behalf of Victor Viscopa.
Thank you.
And Piacenti on behalf of Monica Vescola.
All right. Thank you. With those who intend to testify, please stand and raise your right hands. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth? Thank you. We are set today on a bill of review filed by the movement in this case. And prior to going on the record, there was some changes made to the pre-admitted exhibits. Petitioner's Exhibit 10 will not be included in that list. So Petitioner's Exhibits 1 through 9 and 11 through 13 are admitted, and Respondents Exhibits 1 through 9 are admitted. Okay, let me set you all's time here. Counsel, could you pronounce your name again for me?
Piacenti.
Piacenti.
Yeah, Piacenti.
I got it. Thank you. All right, you all will have 15 minutes aside. This will include any opening and closing statements, should you all choose to make one, as well as any examination. Attorney Ewing, at this time, would you like to make an opening statement?
Yes, I would, Your Honor.
Okay, you may proceed.
Your Honor, this bill of review concerns an adult name change order that was granted by Judge Cooks. My client, the movant, is Victor Vescovo, the name change applicant's ex-boyfriend. Monica, who was living with Victor Vescovo at the time, changed her name to Monica Vescovo without Mr. Vescovo's knowledge or consent. In the petition to change her name, Monica did not mention Victor Vescovo at all, despite the fact that they were living together. And despite the fact that we would learn later in 2023, she considered them to be married at that time. Nor did she mention Victor Vescovo at the hearing on her name change application. She said instead that her name was difficult to pronounce and that she wanted the last name of her father's descent, although Vescovo is not her father's last name. On April 10th, 2023, Monica sued Victor for divorce using her then legal name, Monica Vescovo, claiming she and Mr. Vescovo were married on June 10th, 2018, which was approximately 2 years before she filed the petition asking for his last name. After a 3-day jury trial at which Monica's lawyers continuously referred to her in front of the jury as Mrs. Vescovo, a jury unanimously found no informal marriage, and the trial court entered a declaratory judgment that no marriage existed on February 3rd, 2025. 2 months later, we filed this bill of review asking this court to reopen this matter, grant the bill of review, and deny Monica's request for a name change. Monica, since the final judgment, has continued to use the name Vescovo to falsely misrepresent that she is married to Mr. Vescovo, and we'd like the court to fix that, Your Honor. Thank you.
Thank you. Counsel, would you like to make an opening statement?
Yes.
Go ahead.
This case is not about the marriage case. That case was decided. It's on appeal. We don't know what the end result of that is going to be. This case is about whether someone can force their ex 4.5 years down the road. There's a 4-year statute of limitation. Whether you can reopen a final judgment after all that time when someone has complied with the statutory requirements. There are at least 4 independent reasons he cannot win. One is he has no standing. There's no legally protected interest in him appearing in her name change case. There's no case that allows that. The In re Erickson case shows that not a spouse, not anyone is entitled to citation. Unlike a child's name case where they can get where they do have an entitlement citation, there's none in an adult name change case. So there's no standing. Because there's no standing, this court doesn't have subject matter jurisdiction. Standing's in part of subject matter jurisdiction. It's indispensable, and the court doesn't have subject matter jurisdiction. The statute of limitations I mentioned, that's a third reason. We're past it, and he can't use the discovery rule because there's a fourth reason. He's judicially stopped from saying that he didn't learn about this until June 2021 because he told the court in the marriage case of a declaration that he gave under penalty of perjury, knew about this the month after it happened. And it happened in October 8th, 2020. So he knew by November 2020. That's more than 4 years ago. And so for the merit, he can't show a meritorious defense because there was nothing he could do to prevent the name change if she complied with the statutory requirements. And there's a lot they want to say about fraud. And there's a very important distinction here. What they're trying to say about her fraudulently obtaining the name change, which she didn't, that is irrelevant to this case because you have to show extrinsic fraud, not intrinsic fraud, which is what they're focused on. Extrinsic fraud means there was fraud that kept him from participating. Well, if she had no obligation to inform him of this, there was no fraud in keeping him from participating. He just didn't have a right to do it. And then the last part of the bill of review requirement is unmixed with negligence. He had known about this for over 4 years. He has used and encouraged her to use this name at times. He can't come now and say, open up a final judgment and change it.
Thank you, counsel. Attorney Ewing, you may call your first witness.
I call Monica Vescovo.
Okay. Ma'am, you may have a seat right here. Which notebook should she refer to?
It states petitioners on it.
Okay. And ma'am, make sure you speak right into the microphone.
Please state your name.
Monica Vescovo.
And on September 4th, 2020, you filed a petition with this court to change your name from Monica Alabayu to Monica Vescovo, correct?
Yes.
Could you please turn to Petitioner's Exhibit 1? And I'm going to ask you some questions about that exhibit. First, let me ask you, Vescovo is the last name of my client, Victor Vescovo, correct?
Sorry, I need a second.
Well, you don't need to look at anything yet, ma'am. Is Vescovo the last name of my client, Victor Vescovo?
Yes.
And you were living with Mr. Vescovo at the time you filed this petition for name change, correct?
Yes.
In fact, you listed his address in the petition, right?
Yes, that was my address.
But you did not mention Mr. Vescovo anywhere else or anywhere in your name change petition, correct?
I'm sorry, what's your
You
question?
didn't mention Mr. Vescovo in your name change petition, correct?
I was changing it for professional reasons.
Objection non-responsive.
The same,
Yes or
ma'am, the
no?
question was, you didn't mention Mr. Vescovo in your name change petition, correct?
Yes.
Could you please look at Petitioner's Exhibit 1, which is your petition? And looking at page 1, you are asked, where it says the reason I want to change my name is on page 1, it's little c, 2c. Do you see that?
Yes.
It says current last name is very difficult to pronounce. Also, I am in the process to obtain a real estate license and it will be beneficial to have an easy last name. Did I read that correctly?
Yes.
And additionally, if you can go to page 3. You see, are you at page 3? You see on page 3 where it says request for judgment.
Yes.
And it says, I believe this name change is in my interest or benefit and in the interest of the public, correct?
Yes, that's what the form says.
And you listed your email address, which is Monica Alabayu, correct?
Yes.
And you verified this and swore under oath that the facts were true and correct, correct?
Yes.
And then on October 8th of that year, you appeared before Judge Cooks to testify under oath in support of your request to change your name, right?
Yes.
And again, you said nothing to Judge Cooks about Victor Vescovo, correct?
It was irrelevant, so yes, I
Ma'am,
guess.
yes or no? When you appeared before Judge Cooks and testified under oath, you said nothing about Victor Vescovo, did you?
That was not the reason why I was changing my last name, so.
Yes or no? Did you mention Mr. Vescovo at all at the hearing before Judge Cooks?
I know I did not. I also,
Hearing
I'm so sorry, Your Honor.
question.
You have to wait for her.
I heard tone.
Me. You have to wait for her to ask the next question.
I was wondering if she can her tone is so aggressive and I'm going through a lot right now.
Okay,
and-
she's not. She just wants you to answer the question.
I know.
You have to wait for the next question, okay?
Okay.
Go ahead.
In fact, at the hearing in front of Judge Cooks, you said, I think it's best for me to have my last name from my father's descent, didn't you?
Yes.
You claimed that the name Vescovo was the last name from your father's descent, right?
It's been mischaracterized. Vescovo is Italian and I have Italian heritage.
Vescovo is not the last name of your father. Your father's last
I
name
did
is
not say that.
Alabayu.
I did not say that.
Can we please look at, please turn to Petitioner's Exhibit 2, ma'am, and turn to the page that says 170 on the bottom. It's the third or fourth page.
Objection, relevance. She's going for intrinsic fraud. It's not relevant to whether he is entitled to a bill of review.
Your Honor, the relevance is she just said she didn't say that, and the pre-admitted exhibit shows she did. So I would like to point that out, but I can move on since it's pre-admitted.
I guess the question the court has is, what is it in relation to the elements of a bill of review?
The reason it's relevant, Your Honor, is because she stated that Vescovo was not the name she wanted because she believed she was married to my client, but because She thought it was the name, or she claimed it was the name of her family's descent. So she basically lied to the court about the reason for the name change.
Okay, but I guess my question is, with the three elements of the bill of review, what is the relevance to?
Fraud, Your Honor.
But that's intrinsic.
Also goes to her credibility today in her testimony.
Okay, sustain.
And Monica, after Judge Cooks granted your name change, you did not immediately tell Victor that you had legally changed your name to his, correct?
That's incorrect.
In fact, you continued to correspond with him, the Gmail address, I'll obey you, didn't you?
We've used this instantaneously.
Objection, non-responsive. Ma'am,
Sustain.
looking at petitioners four, can you see there the email between you and Mr. Vescovo dated December 10th, 2020, where you're using the email address Monica?
Which exhibit?
4. I'll move on, Your Honor. On April 10th, 2023, Mr. Vescovo for divorce, claiming you two had been married on June 10th, 2018, correct?
Yes.
Date you allege that you were married to Mr. Vescovo was approximately 2 years before you filed the petition for name change, in which you didn't even bother to mention his name. Is that right?
Can you please rephrase the question?
June 10th, 2018, the date you allege that you two were married was 2 years before you filed the petition for name change, correct?
Objection, relevance.
What's the relevance?
The relevance is fraud, Your Honor. She thought at the time she filed the petition for name change, she was married to my client, and she did not mention that to the court. Her omission was intentional, and it was to obtain the name change without the court being able to inquire as to whether she was actually married or ask any questions so that the court could perform its gatekeeping functions. She didn't tell the court why she thought, if she had said to the court, I'm getting the name change because I'm married to Mr. Vescovo, Victor Vescovo, as of 2018, the court could have said, well, where is he? Have you talked to him? Why have you not presented me with an affidavit? All of the things, but she prevented the court from being able to make that inquiry because she didn't say anything.
All of that is intrinsic fraud, and that goes to
That's a legal determination, Your Honor, and I completely disagree.
Response.
it's intrinsic fraud, and that's not, it's extrinsic fraud. It doesn't go to whether she prevented him from participating. She's actually, she's saying that she deceived the court. Well, find out, because of the finality of judgment, 4.5 years later, she can't do that.
Sustain.
And you also alleged in the petition for divorce that your name was Monica Vescovo, correct?
I believe I filed under initials.
Well, you were referred to as petitioner Monica Vescovo, correct?
I believe so, yes.
And then your attorneys were able to refer to you in the proceedings as Mrs. Vescovo, correct?
It's not only the attorneys, it's everyone that knew that we were married.
You were able to use the name change that you obtained to call yourself Mrs. Vescovo for purposes of a divorce suit, correct?
I was Mrs. Vescovo, so that was my title.
Do you agree that referring to yourself as Mrs. Vescovo implied that you have Victor's last name because you're married to him?
Not necessarily.
Well, that's what you wanted to be implied, correct?
That's incorrect.
Ma'am, there was a jury trial, a 3-day jury trial, and the jury determined that you are not married to Victor Vescovo,
Yeah,
correct?
because you slept with the judge.
Objection, non-responsive.
Sustain.
And there was a final judgment entered that said that you have no marriage whatsoever, declaratory judgment, with Mr. Vescovo. Do you understand that?
Sustain.
Ma'am, since the final judgment was entered, have you continued to tell people that you are married to Victor Vescovo?
Objection. The relevance on this, they filed a suit against her seeking a TRO. They got a TRO when she wasn't represented by counsel. When they got into the preliminary injunction hearing, the TRO was
I'm going to
resolved.
object to the speaking objection, Your Honor, especially if it counts against my time.
It was counting against his time. Go ahead, counsel.
They already litigated this and they lost. So if she can say whatever she wants because we have the First Amendment.
Sustain.
Have you referred to yourself as Mrs. Vescovo since the final judgment was entered?
Objection, relevance.
Sustain.
Since the final judgment was entered, ma'am, Have you represented yourself as Mrs. Victor Vescovo?
Objection relevant.
It's
Sustain.
Pass the witness.
Okay, counsel?
Why did you change your name?
Because I was getting my real estate license and my last name, Alaibe, was mispronounced on my official documents. Every time I traveled with Victor, I was discriminated against. I was always randomly checked if I had bumps in my hands or whatever. So Victor's father was a realtor, and he was 100% on board for me to change my last name to Vescovo.
If you could look at our exhibit folder there for respondent, if you'd look at exhibit 2, could you tell me what this is?
The first page.
Yes.
This is a correspondence with Texas Real Estate Commission about my last name update.
So this is a true, oh, we've already admitted this, or sorry, go ahead. And so what did you tell them was the reason?
That my last name is very difficult to pronounce and would have been very difficult for my clients to pronounce my name. So
And then behind that page, that email, what do you have?
these are, in order to be a realtor, you have to take these courses. And these were the 6 courses I had to complete in order to obtain.
So what was the date of that course? This first one that we see there.
The first one started on August 2nd, 2020.
And went to,
I believe the last course was September 18, 2020.
and then, okay. That's
I'm so sorry, it was September 9, 2020.
that's all we have.
Okay. Anything else from this witness?
I have nothing.
Okay. Ma'am, you may return to your seat.
Thank you, Your Honor.
You're welcome. Attorney Ewing, you witness.
I call Victor Vescovo, Your Honor.
Okay. Sir, if you have a seat right there. And for time check, Attorney Ewing, you have 5 minutes and 26 seconds. Attorney
PHNT.
Piacenti, you have 9 minutes and 47 seconds.
Please state your name.
Victor Lance Vescovo.
How do you know Monica?
We were together as boyfriend, girlfriend for about 8 years.
Did you know that Monica filed a petition to change her name to yours?
No,
Did you consent?
no,
Did you know about the name change hearing or that Judge signed an order that day granting the name change?
no,
Did Monica tell you she had legally changed her name?
no,
Did you participate in a real estate transaction with Monica 3 months after she changed her name?
yes,
Was her name listed as Monica Vescovo in any legal documents?
no.
How did her name appear in legal documents?
Monica Alabayu.
When did you find out Monica had legally changed her name to Vescovo?
Around June of 2021.
How did you find out?
Mail came to my address, addressed to Monica Vescovo.
Did you ask her why she had changed her name to Vescovo?
Yes,
What did she say?
she said she wanted a more convenient name for real estate.
Did Monica email you shortly after you found out, acknowledging that you had found out?
Yes,
And if you could turn to Petitioner's Exhibit 6, is this a copy of the email that Monica sent you on June 18th, 2021?
yes.
And when was this email sent in relation to you finding out about the name change?
Shortly after, a couple of days.
Did you believe Monica's explanation for the name change?
Yes,
Objection relevant.
Sustain.
Was Monica's explanation for the name change consistent with what she stated in the petition?
yes,
Was her explanation consistent with Respondent's Exhibit 2 that we were shown earlier?
yes,
Did Monica ever tell you that she changed her name to Vescovo because she thought you were married?
no,
Did you maintain a friendship with Monica and professionally
Big picture.
support her? Sorry, Your Honor. Oh, did you maintain a friendship with Monica after learning of the name change?
yes, I did.
Did you professionally support her?
Very much, yes.
Would you have done that if you knew she was falsely representing?
No, I would not.
Was there a point at which you came to believe Monica had lied about her reasons for the name change?
Objection relevance.
Sustain.
When did you, when, on April 10th, 2023, did Monica sue you for divorce?
Yes,
And the petition is in evidence. Did she claim in the petition you were married June 10th, 2018?
yes.
Had she ever, prior to you reading that petition, told you that she thought you were married?
No, she had not.
Before you learned about the divorce suit, had she ever identified herself to your knowledge as Mrs. Vescovo?
Not to my knowledge.
Sustain.
Is that something you might have heard her say?
Objection relevant.
Sustain.
Did you file this bill of review 2 months after the final judgment in the divorce suit was entered?
Yes,
Did you file this bill of, it goes to the statute of limitations, Your Honor.
Okay. Overruled.
Did you file this bill of review within 2 years of Monica filing the divorce suit?
yes,
Notwithstanding the final judgment, does Monica continue to use the name Vescovo?
yes,
Do you object to that?
absolutely.
Is it your opinion?
Hold on 1 second. Let me read this back. Notwithstanding the final judgment, does Monica continue to use?
Object to both of those. If she continues to use it because it's her legal name. She's been using that name for 5 years.
We understand that, Your Honor, but
Sustain.
in your opinion, does Monica's use of the name mislead the public about the jury verdict?
Objection relevance.
Sustain.
Why do you object to Monica having your last name? Why are you asking this court to grant a bill of review and reconsider Monica's request for name change, Victor?
Overruled.
Because after winning a trial, clearly that she was not my wife, she continues to represent in public that she is my wife, and the use of my last name gives credibility to that incorrect assertion.
Do you think that that is something that this court should consider today, that Judge Cooks did not consider, that Monica believed that she was married to you when she's requesting the name change?
Objection relevant.
Hold on 1 second. Let me read that back.
The law, that's what the court considers for this matter, not his opinion.
Sustain.
Pass the witness.
When did you find out that Monica had changed her name?
June of 2021.
And what did you tell the court in the marriage case that when you had found out?
Can you be more specific, please?
You had did you have a declaration in support of your original answer in the divorce case?
Yes, I did.
Okay, if you could go to respondents, there's number 1. Is this your answer?
Yes, it is.
Okay, if you could turn to, there's 10 pages of the answer, and if you could go to the declaration behind it.
Okay. There are 10 pages.
Page-
Hold on 1 second. What happened? Hey, go ahead.
Page what?
The 11th page.
11.
Exhibit.
Okay, I was looking for the page numbers.
Right.
Okay, I see it.
Paragraph 20.
Yes.
Could you read the first sentence?
I did not learn about Monica's actual name change until approximately 1 month after it was approved by the court.
And you understand it was approved by the court on October 8th, 2020?
No, earlier in that affidavit, I actually stated I found out later. So the statement I made in paragraph 20 is simply a mistake.
Okay, then let's look at paragraph 18.
I think it was 18.
Paragraph you're referring to?
Let me think.
Could you read?
That's correct. The last statement.
Did you read that paragraph?
Sure. On January 19th, 2021, Monica closed on the Turtle Creek condominium that I purchased for her. The Turtle Creek condominium is deeded to Monica Alabayu, not to Monica Vescovo, even though the purchase occurred over 3 months after Monica fraudulently changed her last name to Vescovo. At the time I purchased the property for her, I did not know that she had changed her name.
So in paragraph 18, you're saying you didn't know as of January 19th, 2021.
Yes.
And in paragraph 20, you said you knew a month after it happened, right?
Well, that's what it says, but that was a mistake. I thought it was a year after.
And you declare this under penalty of perjury, correct?
Yeah, but I made a mistake.
And your counsel submitted this to the court, correct?
Yes.
Did you review this before you signed it?
Objection, Your Honor. Relevance.
It's relevant to the statute of limitations and his credibility. He's got a declaration that's inconsistent within itself. If his counsel submitted that to the court, now they want us to believe that he didn't see his mail for 7 months.
Your Honor, he's already said that it was a mistake. Been asked and answered at this point.
Sustain as to ask and answered.
How often do you check your mail?
It's a non-locked mailbox at my property. I traveled a great deal in 2021, so I often didn't get my mail. It was often left on my kitchen table, or I would retrieve it myself. Sometimes Monica would.
Anybody else retrieving it for you sometimes?
I think on rare occasions, a pet sitter might have done it if we were both unavailable, but usually Monica was in the house, especially when I wasn't there traveling.
Together during 2021?
I think so.
Who would get the mail when you travel together?
The pet sitters.
And so is your position that you never saw anything that was addressed to Monica Vescovo between October 2020 and June 2021?
No, I was traveling a great deal on ocean expeditions, so I was not home that often. So Monica was there taking care of the house.
Take a look at page exhibit 7 for respondents.
Yes.
What is this?
I don't know.
Well, I'm asking you to take a look.
I set up an email account for Monica under vescovorealty.com.
And what is her email address at vescovorealty.com?
Well, this is September of 2021. I knew that she had changed her last name to mine at that point. So it's Monica at vescovorealty.com.
So you acquiesced in her use of Vescovo in her email address, correct?
Reluctantly, but we were still friends. I was trying to help her. My father was well known in real estate circles in Dallas, so I thought I could help her.
And did you help her pay any domain names?
Yes, I was trying to help her start her new career so she could move on with her life.
And what domain names were those?
Vescovo Realty.
So you let her use Vescovo Realty, even though you wanted her to move on with her life. And so I guess you thought those things were compatible, right?
Yeah, people could have thought she was my cousin or some other relation. I have other cousins named Vescovo, and I thought I could help her at the margin. So I agreed. I didn't know she was. Anyway.
So why do you think it's appropriate now to come 4.5 years later and say, oh, I changed my mind?
Because now I realized she did it so she could sue me for divorce.
I think she plotted 2.5 years in advance.
Oh, yes.
Okay. Anything else, counsel?
No, Your Honor, thank you.
All right. Sir, you may return to your seat. Right, you may call your next witness.
I have no further witnesses, Your Honor. I rest.
Okay. He a Chinty? Okay. You may call your first witness.
We don't have anything else we need to say.
Okay. Thank you. The court is going to deny the bill of review. Do you have a proposed order?
I'll submit it. I'm sorry, I ran out the house without it.
If not, I can do I can do an order and submit it to you all. My coordinator will email it.
Thank you.
Thank you. You all may be excused.
Thank you, Your Honor.
Yes, please. Is everyone here on the Jenkins and Chambers case?
Yes, Judge, I believe so.
Good. I'm getting ready to perform this wedding and then I'll take you all up next.
Yes, Judge.
Judge.
All right. You can sit your stuff down right there. Did you all want to do pictures or video, anything?
No.
No? Okay. All right. Well, you have to take a picture of me when we're done.
Yeah, that's fine.
Okay. Donald is Ray David. And is it Sheila or Sheila?
Shayla.
Shayla. You right. You right. Shayla Yadiri.
Yatira.
Yatira.
Yadi.
Yatira.
Yadira.
Yeah, Yatira.
Yatira.
Yadira Gonzalez.
Sí.
Okay. ¿Cubanos?
Yo soy dominicana.
Oh.
Sí, mira.
Yeah.
Y'all ready?
Yes, ma'am.
Okay. So you can come up here. Yes.
Aquí está la que me va a ayudar a que yo lo entienda.
Me gustan los acentos. Gracias. El first name me. Su nombre es Shayla. Shayla. I got it. Okay. One right here, one right here, and then y'all gonna face each other. And hold hands like you move. Okay, you ready? Yes. All right. We are gathered here today to celebrate in holy matrimony the ceremony between Donald Davis and Shayla Gonzalez. Are the two of you ready to proceed with your ceremony today? All right, now you all did sign the 72-hour, you all did sign a waiver waiving the 72-hour statutory period. This is also your agreement to go ahead and proceed with your wedding today.
Yes, ma'am.
Okay, marriage is sacred. It is a covenant under God and it should be entered into soberly and honestly. Don, do you take Shayla to be your lawfully wedded wife, to love, honor, cherish her, be honest with her through sickness and in health until the day you leave her? Okay, Shayla, do you take Donald to be your lawfully wedded husband, to love, honor, cherish him, be honest with him through sickness and in health until death? Okay. Well, by the power vested in me and under the authority of the state of Texas, I now pronounce you listed in white. You can kiss your bride. Oh, yeah, hello, Zoom. Congrats. You like to do that? Oh, were they the reaction? Oh, yeah, they can do it. And we are streaming live on YouTube, so everybody that's watching the YouTube channel, just like you are too.
Thank you. Thank you.
You're welcome. Would you all like to take a picture right on your phone? Just one. I got you. That's what we. Oh. Yes. Y te lo casaron. Let me get you.
You signed this license, you get it real.
Yeah.
Thank you.
Very welcome. Let's not walk it back over. You gonna walk it over now?
You can walk out.
Okay.
You need to do it now?
It's best you already here because the bottom of the garage, so go ahead and take care of it now.
Okay.
Yeah.
Everybody take it.
Back to where you got it from, back to Miss Jackson. Yeah, and she has your waiver on.
Okay.
Okay.
And she said she remember your mama and father.
She does.
Yeah, she said that down, step down. Thank you, Judge. Yes, ma'am.
The lead going in person, I'm waiting on. Oh, okay. Let's get that went out.
Yes, sir.
Okay. All right, bye. See you later. Okay. me set this.
Okay, bet.
Bye, Preesh.
Bye, Judge.
Okay. See. Oh, my book. I need a piece of tape. I tore my book on accident. Okay.
Have to take Judge. You need to take.
Yes, I tore my book on accident. Thank you. Okay. How does that keep doing that? Okay. On Chambers and Jenkins, the movement is Miss Chambers. Is that correct?
That's correct, Your Honor.
Want to make sure I label you all right on my clock. All right, both sides ready to proceed?
We are, Your Honor.
Father is Judge.
All right, thank you. We're on the record. DF 2012698. Councils, will you please announce for the record?
Cassie Hines on behalf of petitioner and movement, Angela Chambers.
Okay,
Brandon Joseph, along with Kate Mattia for the father, Russell Jenkins.
all right. With those who intend to testify, please remove yourselves off of mute and raise your right hand. Okay, do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
I do.
I do.
Thank you. Okay, we're here today on a de novo appeal of the associate judge's ruling. Is that correct?
Yes, Your Honor.
All right. And I have some exhibits in front of me. Let me make sure I get, okay. I see D, and that's for father's side. Is it 1 through 16?
There is, some had been removed. It should be D 1, 2, 4, 5, 6, 7, 8, 9, 12, and 16.
Okay, 1 second.
That's correct, Judge. I agree with Ms. Hines's representation, and I would formally move to offer those into evidence at this point.
Okay.
And no objection if we're pre-admitting.
All right. So move-ins exhibits 1, 2, 4, 5, 6, 7, 8, 9, 12, and 16 are admitted.
Those are correct,
Your
Judge. And just for purposes of the record, I think you maybe said movements exhibits, and my client, the dad, is actually the respondent in this case, just for clarity of the record, Judge.
Okay, thank you. Moving for this de novo appeal.
His mother, yes, Judge. And
His
she was the
mother.
movement in the original hearing as well.
Okay, thank you for that. And respondents exhibits.
I had to email them all separately to Judge Lee, Your Honor, because there were some of the sizes, but mothers, you should just have 1, 2, 4, 5, 7, and 8 for mother.
Okay. Attorney Joseph, does father have any exhibits?
Yes, Judge. Our exhibits were the ones you admitted first. Our exhibits were the 1, 2, 4, 5, 6, 7, 8, 9, 12, and 16.
Okay.
Those were labeled with D at the beginning for dad.
Okay, got it. Okay, Attorney Hines, are your exhibits 1, 2, 3, 4, and 5?
No, Your Honor, mine are 1, 2, 4, 5, 7, and 8.
They came in weird. Okay, 1, 2,
4, 5,
7, and 8.
Yes, ma'am. It's because some of these are like screenshots, and so the attachments were large, so I couldn't send them just in one email.
Okay, I got it. So mother's exhibits 1, 2, 4, 5, 7, and 8 are admitted.
Thank you, Judge.
All right, you're welcome. Okay, I have you all set at 15 minutes aside. This will include any open and closing statements. Should you all choose to make them, you absolutely do not have to, as well as any examination. Attorney Hines, would you like to make an opening statement at this time?
I would, Your Honor, briefly.
Okay, go ahead.
Thank you, Your Honor. Today, there's a single issue for de novo review for the court's consideration. That's whether you should grant the right of first refusal to my client, the mother. They are the parents of a 10-year-old child. They both live here in Dallas. The evidence will show, however, that father travels often. It's either for his second job as a stand-up comedian or for his job that he took. We believe the evidence shows it's out of New York. His testimony is probably that he works remotely, but he does travel frequently. So, Judge, we're simply asking for the court to reconsider letting my client have the right of first refusal so that she can have additional time with her daughter, who is 10, her most formidable years entering into teenage. Your Honor, Judge Lee did clarify for us this morning that a child custody evaluation will proceed. And so, as you know, this case will have some time before we get to a final trial. And that's why we believe the right of first refusal is extremely necessary. Thank you.
Thank you, counsel. Attorney Joseph.
Judge, very briefly, Judge, as you know, my name is Brandon Joseph, and along with Kate Matai, I represent Russell Jenkins. What the evidence is actually going to show you today is that by virtue of the prior order in the last modification suit, my client, Mr. Jenkins, was awarded sole managing conservatorship of the child. Mom was awarded a step-up possession schedule that significantly limited her time with the child. So, I heard Ms. Hines say these were the child's most formidable years. However, Ms. Chambers' own actions put some damper on her ability to participate in those years. What the evidence will actually show the court is that my client has not traveled, that mom's statements are speculative at best. What you're going to also learn, Judge, is that one of the reasons why mom's access to the child was so limited, and one of the reasons why my client has sole managing conservatorship, is because mom has significant mental health issues, and we have significant concerns about her status even as we sit here today. As this court is well aware, and they didn't mention this in their opening because they can't get there, but the burden is on them, and their burden of proof today is to show that what they're asking for would actually be for the safety and welfare of this child. And as this court also knows, several appellate courts in this state have opined and have actually stated that safety and welfare, that burden is higher than best interest. So it's not enough for mom to simply come in today and say, oh, I think dad may be traveling, and because of that, I want more time. There's actually got to be evidence that it's for the safety and welfare of the child, which essentially would show that they would need to show that unless this court enters a right of first refusal, the child is somehow in danger. As this court knows, rights of first refusal are often not granted, often not parts of orders, because it micromanages time. And what you're going to see, Judge, is that what they're asking for is very unreasonable. They're not just asking for a right of first refusal. They're asking for a right of first refusal if my client is away from the child for 4 hours or more. So less than a workday. She wants the right of first refusal when she just, during the pendency of this lawsuit, was able to even start exercising expanded standard possession. So with that, Judge, I would just reserve the rest of our time and just ask the court to deny their request and to affirm Judge Lee's prior ruling.
Thank you, counsel. Attorney Hines, you may call your first witness.
Thank you, Your Honor. I call my client, Angela Chambers.
Okay.
Ms. Chambers, can you please state your full name for the record?
Angela Chambers.
And Ms. Chambers, our exhibits have been pre-admitted, but did we submit a brief summary to the court as Mother's One asking for the court to grant your request today?
Yes, we did.
Why do you think a right of first refusal is important?
I think it's important because Russell is often out of town and either—
Objection, calls for speculation. I'd like to take her on voir dire.
Go ahead.
Ma'am, you just said that Mr. Jenkins was often out of town. Do you recall that?
Yes.
Okay, did Mr. Jenkins ever personally tell you when he was out of town away from your daughter?
No.
Okay, I'm gonna renew my speculation objection at this point.
Sustain.
Ms. Chambers, why is the right of first refusal for you important for your daughter?
It's important to me because I want to be able to spend that time with my daughter when, Russell isn't in town.
Okay.
Objection assumes not in evidence as to when Russell's not in town.
Same.
So, Ms. Chambers, Mr. Joseph brought up a good question. Mr. Jenkins doesn't tell you when he goes out of town, does he?
No.
Exception vague as to time frame.
Ever?
Sustained.
Objection relevant as to ever, because we're in a new lawsuit.
We didn't catch the end of what you said, Attorney
Sorry,
Joseph.
Judge, I'm saying that my objection is to relevance if the question is if he's ever told her, because we're in a new lawsuit, so anything that predates the prior suit would be res judicata.
Okay, counsel, rephrase your question. I already sustained it.
Thank you, Judge. Ms. Chambers, has Mr. Jenkins since January of 2024 ever told you when he is traveling out of town?
No.
Has he ever told you if he's left Eleanor with other adults?
No.
Okay. So Mother's 5. So Russell, how often does Russell do the exchanges with Eleanor at your house?
Objection relevance as to exchanges when we're talking about a right of first refusal.
Your Honor, it goes to how frequent he chooses to co-parent or show up or do any of the exchanges with my client.
Well, the judge.
I'll allow it. Go ahead.
Yes, Judge.
Okay, so since going back from last year to this year through June, I would say the great majority of exchanges were with someone else other than Russell.
Okay. And Mr. Jenkins' social media posts, Mothers 7 and 8, those are in evidence. Can you just ballpark for me how many times he had posted that he was playing a show in another state?
I would say since January of this year, it would be about 9 dates out of the month on average.
Your Honor, may I share my screen?
Yes.
Ms. Chambers, can you see the screen?
Yes.
Okay, so Mr. Jenkins, this is his social media post, correct?
That's correct.
Okay, so 2024 year in review, he says, how many stage performances did he have?
193.
And how many open mics?
101.
And this is a map where he shows all the places that he performed in 2024?
That's correct.
Okay, and so how frequent would you say he was posting that he was out of town on a comedy show?
Section relevance as to how often he made a post.
Sustain.
How many times did he say he was performing out of state on these between 2024 and 2025?
I would say out of state happened more in 2025 than 2024.
Objection non-responsive.
Overrule.
Ms. Chambers, did Mr. Jenkins ever call you up and say, hey, I'm going to be in Portland, Maine at a comedy festival. Can you keep Eleanor tonight?
No, he did not.
Okay. Currently, you have the standard possession schedule. Is that correct?
That's correct.
Okay. You're not supervised, are you?
No,
You have overnights with your daughter?
that's correct.
Do you think that it would benefit your daughter to have time with you instead of someone else if Russell is out of town?
Yes.
Objection calls for speculation.
Fine.
So you're asking the court, based on what Russell has himself said, you're asking this court to allow you to have the time when he travels out of state.
That's correct.
You heard Mr. Joseph talk about the prior order and that you had some mental health issues. As we sit here today, do you have issues that would concern this judge about caring for your daughter?
Objection, it calls for speculation as to what would concern Your Honor.
Sustain.
Okay. Do you have any mental health issues as you sit here today that would impair your daughter?
Objection, she's unqualified to diagnose herself.
It's a personal knowledge question, Your Honor.
Okay, rephrase, counsel, because your
Yeah.
question is, do you have any mental health issues as you sit here today that would impair your daughter?
I'll rephrase, Your Honor.
Go ahead.
Ms. Chambers, you have the standard possession schedule currently, is that correct?
That's correct.
Okay. So if you were granted 4 hours or more overnight, if Russell was out of town, is there anything about that would cause concern for anyone in this room?
No.
Been called for speculation. She can't speak for my client, for example.
Sustain.
I'll pass the witness, Your Honor.
Okay, Attorney Joseph.
Judge, very briefly, ma'am, you have shared with the judge a litany of things you allege my client posted on social media. Do you recall that?
Yes.
You would agree that some of those dates were actually times where you had your daughter. Is that correct?
When I shared those, it was when
Objection non-responsive.
Sustain.
Yes or no, some of the dates listed were days that you actually had possession of your daughter, correct?
No, not the ones that I shared.
Okay. Isn't it also true that during the time period of those posts that you showed the judge, you were not entitled to standard possession, were you?
I had overnights with her, but
Objection non-responsive.
Sustain.
My question
was,
sorry, Judge.
Isn't it also true that during the time periods of those posts that you showed the judge, you were not entitled to standard possession, were you?
I'm going to object as to ambiguous, Your Honor. There's posts from 2025 and 2024. So I'd ask for clarification on the time.
Sustain. Counsel, would you please rephrase and clarify?
Absolutely. The last post that your lawyer had up was from November of 2024. Do you recall that?
Yes.
Okay, you didn't have standard possession in November of 2024, did you?
No.
So you're not faulting Mr. Jenkins for not giving you more time when you were on a step-up schedule, are you? Yes or no?
Can you rephrase the question?
My question is that the court dictated how much time you were supposed to have with your daughter during that time. Is that correct?
That's correct.
And you're not telling the judge that Mr. Jenkins interfered with the court order time, are you?
That's correct.
And you also said that you didn't have anything, you want everyone to believe that you don't have any mental health concerns, but you have bipolar disorder, don't you?
Yes.
Okay. In addition, ma'am, you aren't here today saying that your daughter's in danger with any person with whom Mr. Jenkins may or may not leave her with, is she?
No.
Okay. And in fact, ma'am, you're here today because of something that you want, not what's best for your daughter. Isn't that right?
I think it's good for my daughter.
Objection non-responsive.
Sustain.
Yes or no, ma'am, you're here today because of something that you want, correct?
Yes.
Okay. And in fact, have you been diagnosed with anything other than bipolar disorder?
I have anxiety.
Okay. Are you currently taking medication for either of those diagnoses?
Yes, I am.
And all of these dates that you showed the judge about comedy shows, you know, based on your own exhibits, you don't know what time those shows were, do you?
Objection, it's ambiguous. Which shows are we talking about? There's hundreds.
Sustain.
I'm sorry, my question is, of any of the shows that you showed the court, are you aware of the timing of those shows?
Yes, some of the shows he shared what time they were.
Okay. Do you know if any of those shows took place when your daughter was in school, for example?
I don't know.
Okay, well, it's possible that your daughter could have been in school, and if that were true, then she wouldn't have been left alone with anyone else, right?
Objection calls for speculation.
Well, Judge, my response respectfully is that she opened the door. This is cross-examination. She swore that he was away from the daughter at all of these times, and I think I'm entitled to examine whether that's true.
That mischaracterizes her testimony. She didn't swear that he was away from his daughter.
Hold on, I sustain the objection. Counsel, you may ask your next question.
Judge, so if you're not telling the judge by that list that you admitted into evidence of his post that he was away, then you don't know that he was actually away from your daughter Eleanor during each of those dates, do you?
Some of the dates I do know.
Objection non-responsive.
Sustain.
Yes or no, for each of those dates that you showed this judge on those posts, are you aware whether or not he was actually away from your daughter?
No,
So you just did that for dramatic effect to try to mislead the court, right?
no.
Okay, I'm going to pass this witness, Judge.
Okay. Attorney Hines, any redirect?
Yes, very briefly, Your Honor.
Go ahead.
Ms. Chambers, I'm going to share Mother's 8 since there's some confusion about the timing. Mother's 8, you see this post on the screen?
Yes.
When was this?
This was this year in the spring.
Okay, so a few months ago.
Yeah.
Okay, he's not in Dallas. Mr. Joseph just in his opening said that father never travels.
Objection leading and objection to counsel testifying.
Sustain us to lead and don't lead.
Ms. Chambers, what does Mr. Jenkins say in this post? At the bottom.
Oh, new office view.
Okay, where is this?
That's in Manhattan. That's the Lipstick Building in Manhattan, New York.
Okay, and so these posts, I'm going to scroll through these quickly, but these are from his social media taken after the last hearing. Is that fair?
Yes, that's fair.
Okay, this one right here, Portland, Maine. What does he say?
He says, "My home away from home."
Okay, and he did admit in the other in M7 that was on the map, Portland, Maine. Do you recall that on the map?
Yes.
Okay, so these are all from April forward. This is, what's the date on this one?
May 25th.
Okay, and this is in New York.
Correct.
Okay, so just for the court's clarification, Mother's 8 are screenshots that you've taken from Mr. Jenkins since the last hearing.
That's correct.
Okay. Nothing further, Judge.
Okay. All right. Counsel, you may call your next witness.
Thank you.
I'm sorry, Judge. I do have some more questions.
Oh, I'm sorry. Attorney Joseph, go ahead.
You are aware that your Mr. Jenkins has taken your daughter Eleanor to Maine. Is that correct?
No, I'm not aware of that.
You didn't know he went on a family trip?
No, I was not made aware of that.
You are aware that Mr. Jenkins has provided proof that his job is remotely because we sent an exhibit to your lawyer that we aren't using today, but you've seen that, right?
I've seen that exhibit.
So even after you saw that exhibit, at least yesterday, you're here today telling this judge that you still believe he works in New York?
I think he travels there.
Objection non-responsive.
Dang.
Even after you have knowledge that his job is remote, you're telling this judge today under oath that he works in New York.
Your Honor, I'm going to object. That mischaracterizes her prior testimony.
Well, Judge, I think you recall what she just said. He got a job, and that's the Lipstick Building. It's in New York.
She did not testify that he's working in New York. That mischaracterizes her testimony.
Okay, sustain.
Don't think he's working in New York.
I'm sorry, say that one more time.
You know he's not working in New York.
No, I don't.
Okay. But you don't know that.
For child support and medical support, is it Miss Kuros? Is that how you say your client's name? Kuros or Kuros?
Heroes, yes, Your Honor.
Okay. All right. Mr. Navaez, are you ready to proceed by yourself?
And I guess, yeah.
Okay. 1 second. Let me set you all's time. All right, you ready?
Yes.
Okay. We're on the record in cause number DF 22122356. Counsel, will you please announce for the record?
Diana Lay on behalf of the petitioner Beatrice Quiroz.
All right. And Mr. Narvaez, you are the respondent in this matter, is that correct?
Yes, ma'am.
You will be proceeding representing yourself today, is that also correct?
Yes, ma'am.
Okay, we're here for a motion. We're here on a motion for enforcement for child support and medical support. Are there any preliminary matters that the court needed to take up, or are both sides ready to proceed?
We're ready to proceed, Your Honor.
Okay, Mr. Narvaez, are you ready to proceed?
Yes, ma'am.
All right. Okay, those who intend to testify, would you please take yourself off mute, raise your right hand. All right, do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Thank you. You may lower your hands. Attorney Lay, you may proceed.
Thank you very much, Your Honor. Now, before we begin, we do have petition exhibit 1, which is our requested relief for today, Your Honor.
Okay.
Can you please move to introduce that as an exhibit?
All right, Mr. Narvaez, are there any objections to petitioner's exhibit 1? Or have you seen it?
No, ma'am.
Okay.
I did email it, Your Honor. I apologize.
No worries. I think the easiest thing to do, Attorney Lay, is probably to share your screen so he'll have an opportunity to look at it that way.
Yes, Your Honor. And this is our requested relief, Your Honor, and we have marked it as petitioner's exhibit 1.
All right. Mr. Narvaez, do you have any objection to this document?
No, ma'am.
Okay, petitioner's exhibit 1 is admitted.
Thank you, Your Honor. Okay, I call my client, Your Honor, Ms. Quiroz.
Okay, you may proceed.
Thank you. Ms. Quiroz, we have a temporary orders entered through the court, correct? In which the court ordered child support and medical support.
Correct.
Okay, and permission to share screen, Your Honor.
You may.
Hey, Ms. Quiroz, I'm showing you the temporary orders that were signed by the court, and it's been labeled as Petition Exhibit 2. Specifically, this order does order monthly child support and medical support, correct?
Correct.
Specifically, starting December 1st, 2022, Mr. Narvaez was ordered to pay you monthly child support in the amount of $1,240, and on the first day of each month thereafter. Is that correct?
Correct.
And he was also ordered to reimburse you the cost for private health insurance that you provide for your daughter. Is that correct?
Yes.
And that amount is $82. Is that correct?
Yes.
And he was ordered to pay you $82 starting on December 1st, 2022, and the first of each month thereafter, correct?
Yes.
And this is a signed copy of the temporary order signed by the judge, correct?
Correct.
You're going to move to introduce Petition Exhibit 2.
All right, any objection, Mr. Narvaez? You're on mute.
No, ma'am.
Okay, petitioner's exhibit 2 is admitted.
Thank you, Your Honor. Now, Ms. Quiroz, Mr. Narvaez had been paying you directly, is that right?
Yes.
Okay, and in our motion for enforcement of child support and medical support that's on file with the court, we did outline the payments that you received directly from him, correct?
Correct.
And then permission to share screen again, Your Honor.
You may.
Thank you. Okay, I'm showing you, this is the motion for enforcement that we filed with the court. And we pretty much outlined the dates that he had to pay you child support and the dates you did not or did receive funds from him, correct?
Yes.
So based upon the motion for enforcement that you filed with the court, for the month of December 2022, he was ordered to pay you $1,240 in child support, correct?
Yes.
And for that month, did you receive anything from him?
No.
Okay, and for the month of January 2023, he was also ordered to pay $1,240. Did he make any payments to you during that month?
Yes.
Okay, and is it correct that he paid you $450 and $300 for the month of January 2023?
That's correct.
And then for February 2023, again, he was ordered to pay you $1,240, but did he pay you anything for that month?
No.
For the month of March 2023, he was ordered to pay you $1,240. Did he make a payment to you directly during that month?
Yes, he did.
And how much did he pay you for that month?
That was $400.
Okay, and then for the month of April 2023, again, he was supposed to pay you $1,240. During that month, did he make any payments to you?
No.
Okay, and then for May 2023, again, he was ordered to pay you $1,240 just for child support. Did he make any payments to you directly?
Yes.
And how much did he pay you?
$300.
Okay, and for the month of June 2023, again, he was ordered to pay you $1,240. Did he make any payments to you directly for the month of June 2023?
Yes.
And how much was that for?
$300.
$200, you said?
Yes.
Okay. Now for July, and also he made another payment in June, correct?
Yes.
And how much was that for?
That was the $250.
Okay. And then for the month of July, did he make any payments to you for that month?
No, he didn't.
And for the month of August, did he make any payments to you?
Yes. He
And
made payments of $300 and then the $120.
okay. And after we filed this motion, so for the months of September and October and November, did he make full payments of $1,240?
No.
Okay, since the end of August till now, how much child support has he paid you directly?
$150.
Okay, even though each month he's ordered to pay you $1,240 per month, correct?
Correct.
Okay, and typically, how does he send you this money?
He sends them through sale.
Okay. Now, regarding the medical support of $82 per month from December 1st, 2022 until the end of August 2023, has he made any payments towards the $82 per month in medical support that he's ordered to pay?
No.
Okay.
I object, Your Honor.
What's your legal objection?
I've sent a payment for the medical support and a lump sum for the other month. I didn't send it monthly and it's not on there.
All right, so I'm going to overrule that objection, but when it's your turn to cross-examine her, then you can bring that up.
Yes, ma'am.
Okay, you may proceed, counsel.
Thank you, Your Honor. And that's why today we are requesting the court order a judgment against Mr. Narvaez for unpaid child support and medical support from December 1st, 2022 as of August 31st, 2023, correct?
Correct.
And we calculated the child support arrearages as $8,840, correct?
Correct.
And the medical support of $738, correct?
Correct.
So all combined, that would be $9,578, correct?
Yes.
And we do need Mr. Navarez to make a lump sum payment, correct?
Yes.
But you are requesting the judge order him to pay $1,000 by December 29, 2023, correct?
Correct.
And then he should make monthly payments towards the arrearages in the amount of $300 per month until that balance is paid off, correct?
Correct.
And we are requesting the court hold him in contempt for failure to pay medical support and child support, correct?
Correct.
And we have requested, based upon our request of relief, that he's held in jail for 14 days or for however long the court deems appropriate, correct?
Correct.
And because you had to hire me to prepare this motion, to serve him and to pay filing fees and to appear at the hearing today, you are requesting that he pays $1,500 in attorney's fees, and that could be collected as child support, correct?
Correct.
Okay. And in fact, we also had a hearing before Judge Lee on his motion to modify temporary orders, and Judge Lee ordered him to pay $500 in attorney's fees to you, correct?
Correct.
And to your knowledge, has he paid that at all?
No.
Now, Ms. Quiroz, does he send you harassing text messages?
Yes, at times he does.
Okay, and specifically, I'm going to show you a text message conversation in which you screenshot, and it was through app close, correct?
Yes.
Okay. Now, this was dated September 16. Do you recall what he was saying to you September 16 of this year?
He says a lot of things, so I'd have to go back on the app close.
Okay, I'm going to share screen with permission to share screen, Your Honor.
Go ahead.
Okay, now this is labeled as Petitioner's Exhibit 3. Now, is this a screenshot of the app close conversation you had with him September 16?
Yes.
Okay, now looking at this exhibit, do you recall what type of words he was directing at you?
Yes, he was arguing with me about something that happened at drop off.
Okay, and he called you a foul woman and things of that nature, correct?
Yes.
And that you tricked him into having a baby with you,
Yes.
and that you just wanted his money.
Yes.
And this was September 2023 of this year, and he had paid you very little child support. Is that correct?
Correct.
Have you altered this conversation anyway?
No.
You already moved to introduce Petition Exhibit 3.
Any objection?
No.
All right, petitioner's exhibit 3 is admitted.
Thank you, Your Honor. Now, this is just one of the many messages he would send you, correct?
Correct.
And Ms. Quiroz, regarding the testimony you just provide to the court right now, as far as the payments you receive from him directly, are those the only payments he has given you since December 1st, 2022 up until now?
Yes.
Okay, and again, the motion to enforce does not reflect the more recent payment of $120?
$150.
$150, I apologize. And when did he make that $150 payment to you?
I believe that was the month of November.
Okay, and again, that was not included in the motion to enforce, correct?
No.
Okay, so you're requesting the court grant all of your requests of relief that we have outlined in Exhibit 1, correct?
Correct.
Okay, pass witness, Your Honor.
Okay. Now, Mr. Narvaez, this is your opportunity to ask any questions of Ms. Quiroz based on her testimony that she just gave. Now, these are questions. You can't make statements or anything like that. Just ask her questions, okay?
Yes, ma'am.
All right. And understand that her attorney has the opportunity to object.
Yes, ma'am.
Okay, you may proceed.
Okay, so is it were Ms. Quiroz, were you or were you not ordered to tell the father of Allison that whenever she has a medical appointment?
Objection relevance.
All right. Mr. Narvaez,
Okay.
what is the relevance?
On September, I sent her medical support. So I'm that's what I'm getting to.
Okay, well, I'm going to sustain her objection to that and just ask questions related to the motion.
Okay.
Okay.
On the month of September, did you or did you not receive medical insurance support for Allison?
Objection to relevance, Your Honor. Our motion covers up until the end of August 2023. So any payments he may have made during September, that's not what we're seeking confirmation of today, Your Honor.
Sustain. So, Mr. Narvaez, it may help. Attorney Lay, would you please bring up the motion for enforcement?
Yes, Your Honor.
It may help if you're actually looking at the violations themselves. So you'll know exactly what she's speaking about, like the dates. So the dates here are December 1st of 2022 through August 1st of 2023. That's for both child support and medical support. So any questions you want to ask related to any payments that you are saying that you made to her, you're going to ask based on those dates.
Okay.
Okay.
So is it true or false that you received medical support from Allison's father within this time period stated in front of us?
I didn't.
So is it true or false that you have or have not sent the receipts for medical receipts to Allison's dad whenever you've taken her to the doctor?
Objections are relevant, Your Honor.
Overrule. You may answer the question.
No, I have not.
So if I were to pull up some receipts that you have sent of the deduction payments that you have to pay at the doctor's, you're saying you did not receive any payment for those from the father of Allison?
Your Honor, I'm gonna object. We're not seeking unreimbursed medical expenses today. We're seeking strictly the $82 per month for cash medical supports or to pay each month plus child support.
Your Honor, I'm trying to get to the point where I've actually paid her medical expenses every time she's gone. It's not a lot, but I have covered it.
Okay, so that's what she's saying. I'm going to sustain the objection. What she's saying is they're seeking confirmation on what you were ordered to pay monthly, that $82. Attorney Lay, would you scroll down on the motion for enforcement? You see these payments here, December 1st, 2022 through August 1st of 2023. That's
Yes,
what
ma'am.
you were ordered to pay under the temporary order, not the expenses. So any questions that you have should be related to those payments.
Okay. So the only question I have is, have you received any Zelle payments directly for medical support for Allison Narvaez?
No.
And Your Honor, I'm gonna object as to he needs to
That's
live time frame.
I didn't get your
Object as to time frame, Your Honor.
sustain. Mr. Navarez, so that objection means that you weren't specific on which time you were actually talking about. Make it specific, so you're talking about the dates that
Okay.
in this time frame.
Okay, so in the February month of February, Allison went to the doctor. Okay, did she or did she not?
Yes.
Okay, and did you or did you not send in the app close app a receipt or of the visit to the doctor?
I object against irrelevant, Your Honor. Seems like out of unreimbursed medical expenses he's asking about.
Okay, sustain. Mr. Narvaez, let me
Okay,
explain it a little
final
bit.
question. Let me just give one more question in on this topic. In the month of February, did you or did you not receive an amount for medical expenses for Allison?
I object against irrelevant, Your Honor, as far as medical expenses.
Sustain. Mr. Navarez,
Medical support.
that's what I was trying to tell you. You have to stick to what their motion said. They're not asking for reimbursement on unpaid expenses. She's asking for you to be held in contempt for not paying your monthly medical support amount of $82.
Okay, so I guess my question is, Ms. Quiroz, did you receive medical support for Allison Narvaez in that month?
No, I didn't.
So if I were to pull up in the app close, there wouldn't be any documentation of me sending you medical support for Allison Narvaez?
No.
And in no months, have you received any medical support in the month of December, January, February, March, April, May, June for medical support for Allison Narvaez?
No.
So you're telling me that you have not received anything in any of these months for medical support.
Objection asked and answered, Your Honor.
Okay. Okay. Your Honor, I'd like to submit the medical, actually, I sent it in an email to the court's official report where it says medical expenses, medical support for Allison Arvaiz. It's written on there where she has received. Could you pull it up, please?
Okay, did you send Attorney Lay your exhibit?
I did not see it, Your Honor.
Okay,
She should already have it on file, because it was sent with my attorney. So she should already have the documentation from the Zelle files.
okay, let me pull up what I think you're talking about. I think this is what he's talking about. Is this
Yes,
it?
ma'am. Yes, ma'am. So if you were to scroll down.
Well, you have to properly admit it first.
Oh, I see. Is this admitted to the court? Do you object?
I'll scroll all the way down, Attorney Lay, so you can see.
Your Honor, I object as to foundation. He hasn't laid the proper predicate to what this is exactly.
It's medical support, ma'am, that she's received the payment. She's denying it. It specifically says on there, medical support for Allison Narvaez.
Okay, what is it though? What are we looking at?
It's the amount sent for medical. It's $120.
Okay,
and in additional to the amount that was sent for child support.
okay, so let me ask you a better question. What
ma'am.
is this? Like, what record is this?
Okay,
You're on mute.
okay. This is for the medical when Allison's doctor's appointment or medical expenses. There's a direct payment for the month of I can't see it for that month.
Okay, so is it just, are you wanting to admit this for one payment, or are you wanting to admit it for all the payments? Like, what do you want to do?
I would like to admit it for child support payments, and also there is a medical expenses on there. And what I was getting to was that she's saying she has not received anything, and on there it says she has received medical support.
Okay, how are you sending these payments to her?
I'm sending them directly through Zelle, ma'am.
Okay. All right.
And she said she denied it and said she hasn't received it. So my point was that it says on there medical support for Allison Arvaiz, a separate delivery. So she's lying, basically.
Okay. Counsel, any objection?
I'm a still object to foundation, Your Honor. He did not identify what those are exactly, other than he's saying they're direct payments to mom for, I forget the word, support he's saying, but he did not lay a proper predicate as to where those figures are coming from, where these screenshots of exactly.
What are these screenshots of, Mr. Narvaez?
They're child support payments and medical support payments for Allison Arvaiz.
Okay. Is this from your Zelle account?
Yes, ma'am. It's from a Zelle account, and it's directly to Beatrice Quiroz' Zelle account.
Okay. The objection is overruled. I'm going to admit them. Let me pull this up. Yeah, I need to, let me see if it'll let me save it as a picture. It's not letting me, he doesn't have to, because it's gonna be the same thing. I'm trying to share the screen.
Let me do it this way. I'm trying to enlarge it. I think I did it. Okay. All right.
Okay,
Now
so
you'll just have to tell me where to scroll.
got you. So if you were to scroll down, um, it's not on there. It should be on the first one. Right there. So are you on the Beatrice Quiroz? Can you see the exhibit in front of you? Miss Beatrice Quiroz, can you see where it says August 29th?
Yes.
Okay, and what does it say under the August 29th that the money sent was for?
She had a doctor's visit that day. And you sent that.
Objection on answering.
Sustained to non-responsive. His question was, what does it say under August 29th for the money was sent for?
Medical insurance coverage for Allison.
So you have received money, medical insurance coverage for Allison Narvaez, then haven't you?
For that one office visit.
Objection, ma'am, not answering. Yes or no?
Sustained.
Yes.
So you just said you didn't receive any medical coverage in the court, didn't you? For medical coverage.
Yes. That was that one time.
So, Your Honor.
Remember, you're asking her question.
Your Honor, I'm finished. I'm
Okay.
done answering. Yes, ma'am.
Okay. All right. Attorney Lay, redirect.
Yes, Your Honor, can you pull up that exhibit for me again, please?
Sure. There you go.
Okay, thank you. Can you go back to, oh yes, okay, right there. Now, Ms. Quiroz, you see that one that says August 29, 2023, $120?
Yes.
Now, in our motion for enforcement, you did give him credit for $120 for a payment made on August 29, 2023, but we put it in the category of child support, correct?
Correct.
Okay, so you weren't lying that you didn't receive
Objection,
money.
Your Honor. It isn't on her exhibit the month of August.
Overrule.
Okay, so ma'am, just because he put medical insurance coverage, did we allocate that 120 in your motion for medical support?
Yes. It's on there.
It's on there, correct? We gave him credit for child support, correct?
Yes.
Okay, and also he made a payment of $300 for you on August 27, 2023. We also gave him credit for that, correct?
Yes, correct.
And even looking right now.
Objection, Your Honor. If you look up her exhibit on the month of August, it's blank that I have not paid anything.
He did not say a valid objection, Your Honor.
What's your legal objection?
I don't remember. I don't remember, Your Honor.
Okay. The objection is overruled.
Okay, I am done with this exhibit, Your Honor.
Okay.
Thank you very much. Okay, and I'm going to share my screen since Mr. Narvaez is so, it has questions about our motion. Okay, pulling up petition exhibit 2 again, which is the motion for enforcement. Now, this is a section that we discuss about child support that he did not pay, correct, Ms. Quiroz?
Correct.
Now, clearly here, it says right here, August 29, 2023, we gave him a credit of $120, correct?
Correct.
And August 28th, you also get another credit of $300, correct?
Yes.
Because the child support is $1,240, did we deem it more appropriate to give him credit of direct payments he made to you in the child support versus the medical support?
Correct.
Okay. So you were not lying when you testified to the court that you did not receive medical support, correct?
Correct.
Instead, we allocated the funds that you received directly from him to child support, correct?
Correct.
I pass the witness, Your Honor.
Okay. Anything further of this witness?
No, ma'am.
Okay. All right. Attorney Lay, you may call your next witness.
I'll call Mr. Narvaez, Your Honor.
Okay, go ahead.
Now, sir, are you aware that per the temporary orders, you're ordered to make the child support payments through the state disbursement unit? Are you aware of that?
Yes.
So why did you send money directly to my client after the temporary orders was signed by the court?
I called the office and I attempted to make payments directly to them. But there was no way for me to make the payment. They asked me for a 10-digit PIN. I didn't have that. They asked me for things that I didn't have. I was unable to make those payments through there.
Did you try to send them money orders or checks?
No.
Okay, objection, non-responsive after no.
Sustained. Wait for the next question.
Now, sir, you saw a motion to enforce specifically for the months of December 2022 up until the end of August 2023, correct?
Yes.
And did you understand you're ordered to pay $1,240 per month just for child support every month?
Yes.
And sir, is it true that you did not make full payments of $1,240 to my client from the months of December 2022 up into the end of August 2023?
I was financially incapable
Objection,
of making those
non-responsive.
payments.
Sustained. The question was, and did you understand you're ordered to pay $1,240 per month just for child support every month? Yes or no?
I wasn't capable of making those payments. Hello?
I will still object to non-responsive, Your Honor.
Sustained. It's a yes or no question.
Um,
Not whether or not you could make it.
Okay, so
you'll have your
yes,
opportunity to
yes,
speak.
I understood. Yes, ma'am.
Okay.
Yes, ma'am.
Sir, and also, we went to court in front of Judge Lee on your motion to modify, correct? Temporary orders.
Yes.
Okay, and Judge Lee ordered that you pay my client attorney's fees after your motion was dismissed, correct?
Yes.
And
I was denied. I was denied.
Sir, the question is, my next question, you were ordered to pay $500 in attorney's fees by the month of October 2023, correct?
Yes.
And you have failed to pay that as well, correct?
Yes.
What guarantee can you give this court today that after today's hearing, you will make your monthly child support payments to my client?
I can guarantee if I'm given the proper information from the Attorney General's office that it will be paid. If I'm given the 10-digit PIN and all the information needed.
But sir, are you saying because you don't have that 10-digit PIN, you couldn't tell my client the full amount of child support? Is that where you're telling the court today?
No, your question was if I could guarantee that if the payments would be made, and I'm saying they would be made if the 10-digit PIN is given. I can guarantee they will.
Sir, I don't care if there is a 10-digit PIN or not. How can you guarantee Judge Bailey today that every month you will send $1,240 on behalf of yourself to the child support office, or even if you Zelle it? What guarantee can you give the court today that you will Zelle or pay to the child support office $1,240 per month for child support? You have not done it since December
No.
2022,
No,
correct, sir?
no, I have not.
So you cannot guarantee that after today, you will pay $1,240 per month in child support, correct?
Not, no.
Do you have any intention of paying $1,240 per month after we leave court today for child support?
No, no, not that amount. No.
Have you filed anything with the court to modify child support as of right now?
I have not yet. No, ma'am.
However, several months ago, you filed a motion to modify temporary orders so you could have primary care or 50-50 custody of the child, correct?
No.
Why did you file that motion to modify several months ago in front of Judge Lee?
I filed a motion to modify visitation to have more visitation to standard possession.
Okay, so you're able to file that motion on your own, but you did not file a motion to modify child support, correct?
I don't have the proper
Objection non-responsive.
Sustain.
So my point is, sir, several months ago, you by yourself filed a motion to modify possession access, correct?
Yes, I did.
But you have not filed a motion to modify child support, correct?
No, ma'am, I have not yet.
And sir, when did you release your attorney officially? Your previous attorney?
They just, I didn't actually release them. They just stopped representing me for lack of payment.
So you have a history of not paying people, correct?
I can no longer afford it.
So you have a history of not paying my client the full child support amount. You have a history of not paying your previous attorney. So how can Judge Bailey believe you today that you will make a lump sum payment as we requested towards the $9,000+ you owe in temporary child support and medical support after we leave court today?
I was trying to get at is they can take it directly from my income. That's the only guarantee I can give.
So why don't you just do it, sir? Why don't you just take it from your income and send it?
I've tried. I'm trying to send it through the Attorney General's office,
Or
and
sir-
there's no way.
Or sir, send it to my client via Zelle. Why don't you send the money to
because
my
I can't afford it. I can't send money I don't have.
Okay, so it doesn't matter if your employer receives a withholding order to withhold money from your income, correct?
Yes.
Okay. Have you taken any vacations, sir?
No.
Have you done any Christmas shopping, sir?
No.
Have you purchased anything for your daughter for the month of December 2023 so far?
Yes, I bought her a pair of shoes.
Did you give it to her?
Yes.
When did you give it to her?
A few weeks ago.
So for November, you bought her a pair of shoes.
Yes.
Okay, and so you heard my client testify that as of I guess September 2023 up until now, you've only paid her $150, correct?
Yes.
But even after you're served with a motion to enforce, you only paid $150 to my client.
Yes.
And did you understand in our motion to enforce, we requested that the court holds you in contempt and you are jailed for your lack of payment of child support?
Yes.
And despite that, you only paid $150 in child support, correct?
I couldn't afford it. I don't have the money. How can I pay something I don't have if I don't
Objection
have it?
non-responsive.
Sustain.
Sir, you saw the text message that you sent my client that we introduced Exhibit 3, correct?
Yes.
Is it true that you send harassing messages to my client?
No, that was a one-time isolated incident.
Oh, this is only one time, sir, that you
Well,
called her.
as of recently, I haven't, we don't talk.
Correct, but you message her on app close, correct?
Yes, on the day of September 6th when she assaulted my elderly mother.
Objection non-responsive after yes on the day of September 6th.
Sustain.
I passed the witness, Your Honor.
Okay.
I like to call myself, Your Honor.
Hold on. It's still Attorney Lay's case.
Oh.
Attorney Lay, you may call your next witness.
I'll call myself, Your Honor.
Okay, go ahead.
Your Honor, I've been licensed by the state of Texas for 11 years now. I've been practicing family law for 10 years. My hourly rate is $250 per hour. I think that's a fair, reasonable rate for an attorney with my experience in the city of Dallas. For filing this motion and the filing fees and process server fees, and also the cost to prepare, defend, and also appear today, my client has incurred $1,500 in attorney's fees. We're requesting the court order Mr. Narvaez to pay $1,500 in attorney's fees to my client and collectible as child support. And I pass myself, Your Honor.
Okay, Mr. Narvaez, do you have any questions for Attorney Lay?
No.
Okay. All right, Attorney Lay, you may call your next witness.
Petitioner rests, Your Honor.
Okay. All right, Mr. Narvaez, this is your opportunity to speak to the court. You because you are representing yourself, Attorney Lay has the option to cross-examine you about the testimony that you give, okay?
Yes, I'm aware.
You may proceed with your statement.
I'd like to call myself, Your Honor, if I may. So I've lost my job as of recently as a result of having to come to court for 2 different court cases. So I have been, so I'd like to point out to the court that I am currently unemployed.
Okay.
So as of recently, I have been unable to fulfill my obligations, my financial obligations to Ms. Lee, to my own attorney that represents me, to for my own child. But, Your Honor, the only way I called the Attorney General's office, I gave them my birthday, I gave them my child's birthday, I gave them my social security number, and they were unable for me to be able to pay my child support directly to the Attorney General's office. That's why I was unable to make those payments. There's no record at all. I made the attempt. I've called multiple times, and that's why I had to pay directly through Zelle. As far as the $500 for Lee that she's seeking, I once I start working again, Your Honor, which is here soon, I'm on my final interview. I'll be able to fulfill all my financial obligations. I don't run away from responsibilities. I don't run away. And so, I mean, I'm not denying child support for Allison Narvaez. She should have child support, but I think it should reflect my job that I'm going to have now, and not the job that I had before, because 6-figure jobs are hard to come by. They just don't grow on trees. So I would ask the court to allow me to, once I get hired this week, which I'm on my, that should be hired already, to allow me to send in my my check stubs so that the amount for reflection of the child support, can be taken from there. And if I have to file another motion, I will, for the child support.
All right. Does that conclude your statement?
So I just want to make it clear, I haven't been able to pay through the Attorney General's office because there is no record. Every attempt was made to make these payments through the Attorney General's office since the month of December. There is no record. I gave my Social Security, my birthday, Beatrice's birthday, my child's birthday. There was nothing there. They could not find anything. And I'm talking, I called month after month after month, and there was nothing for me, no way for me to pay it. So if I wouldn't have Zelled her directly, she would have had no money, no way to get the money directly. And also the thing is that I lost my job for having to go to court, for this court and another court. I'm not running away from my obligations, my responsibilities. That's not in my character. That's not the way I am. But if I'm financially unable to meet these demands, there's no way I can do it. I mean, there's just no way. And like I said, I am going to start working this coming week, and I would like the court to deny the contempt and jailment for contempt of court, as long as I'm able to make payments to Ms. Quiroz in the form of child support payments through the Attorney General's office. That's it.
Okay. Counsel, any cross?
Yes, please, Your Honor.
Go ahead.
Sir, the two cases you're talking about, it's the child custody case plus the protective order case, correct?
Yes, ma'am. The domestic violence.
Okay, and we had 2 hearings on that protective order, correct?
I don't recall.
We had a hearing before Judge Lee. We had a hearing for Judge Beecham, correct, for the protective order.
I guess so. I don't recall what exactly they were for.
And then you filed de novo appeal, correct?
I don't recall, like I said.
Okay, so a protective order was issued against you, correct, sir?
Yes.
Okay. Now, since when have you been unemployed?
Just a couple of months. I'm going on a little over 2 months.
So that would be October, would you say?
October, November, and this month, December.
Okay, so permission to share screen again, Your Honor?
You may.
I'm going to show you our motion to enforce. Okay, so you said you lost your job October 2023, correct?
Yes, ma'am, I did.
That's the reason why, and that's the reason why you've been unable to pay child support in the full amount, correct?
No, that's not what I'm saying.
Isn't that what you said, that you're unable to pay because you don't have a job right now?
No, I'm unable to pay these months, send any support, not the full amount. I couldn't afford the full amount from the beginning in the first place.
But the child support is based upon your income. You understand that, right, sir?
Yes, I do.
Okay, so for the month of December, you were employed, correct?
Yes.
But you paid nothing for December, correct?
I was new to the
Objection,
process.
non-responsive.
I didn't.
Fine. It's a yes or no answer.
No, no.
But even before December 2022, based upon the exhibit that you had admitted, you were sending Ms. Quiroz Zelle payments, correct?
Yes, I was sending her money since the beginning of the separation.
Okay, so
Yes,
even
before December.
okay, so you're familiar with zelling her money, correct?
Yeah. Yes,
Okay, a non-response after yes.
Sustain.
So for the month of January 2023, were you still employed by your employer?
Yes.
And who were you working for at that time?
I was working for Ozarka, Blue Triton Corporation.
Okay, and how long had you been working for them in January?
For 4 years.
For 4 years, okay.
January, and that time, 3 years.
Okay, so for the month of January, is it correct that you only gave my client $750 in direct payments?
Yes, I sent her $750.
Okay, in the month of February, were you still employed by Ozarka?
Yes.
But you paid her nothing for February, correct?
I guess so.
And for the month of March, were you still employed by Ozarka?
Yes.
And you only paid her $400 via Zelle, correct?
I did because I couldn't afford to send her the
Objection,
full amount.
non-responsive after I did.
Sustain.
Now, for the month of April, were you still employed by Ozarka?
Yes.
And you paid her nothing, correct?
I couldn't afford it.
Objection, non-responsive.
Sustain.
For the month of May, were you still employed by Ozarka?
Yes.
And she gave you credit of $300 payment that you made to her on May 30th, correct?
Yes.
Okay, in June, were you still employed by Ozarka?
Yes.
And you only gave her $200 on June 12th and also $250 on June 26th, correct?
Yes.
So for the month of June, you were fully employed by Ozarka, who you had been working for at least 3 years, but you only sent her $450.
Yes.
Okay, in July, were you still working for Ozarka?
Yes.
And you sent her nothing, correct?
Yes. I couldn't afford it.
Objection, non-responsive after yes.
Sustain.
And for the month of August, you only sent her $420, correct?
Yes.
And you were still employed by Ozarka, correct?
Yes.
And you did not lose your employment with Ozarka until October, you said, of this year, correct?
Somewhere around there. Yes. Yes.
So that was your last question. You just ran out of time.
Thank you, Your Honor.
You're welcome. Mr. Navarez, is there anything else you would like for the court to know?
Yes. I'd like to call myself again. So I was unable to fulfill all of my financial obligations. That's why I couldn't give her the full amount. I was paying a lawyer, 2 lawyers. I was paying on top of that my own bills, my mortgage, my home payment, my auto payment, regular expenses. And I would like to also point out to the court that Ms. Quiroz was living at her parents' house with no mortgage.
Relevance, Your Honor.
Sustain.
Okay, so the relevance is that
But no, you don't argue I've already made the ruling.
I'm sorry.
You were doing fine when you were talking about
I hear
you haven't been able, you've been unable to fulfill your financial obligations.
Yes, because the amount was so much. It was 1,200. I think in total was 1,300 or so dollars. I was unable to fulfill the full amount because I had so many expenses going out with the attorney fees and my mortgage. But nonetheless, I still managed to send Ms. Quiroz the extra money that I had in my pocket every month. And if I did not send her any money, it's because I did not have any money that month. So I was literally left on zero for that month with $5 to my name. So I have given her every amount of resource that I had every month.
All right. Does that conclude your statement?
Yes, ma'am.
Okay. Do you rest?
Yes, ma'am.
All right. So the court, after hearing both sides of the testimony as well as review of the motion for enforcement, the court finds Mr. Navarez in contempt for violating the provisions of the order, specifically failing to pay child support on December the 1st, 2022, January 1st, 2023, February 1st, 2023, March 1st, 2023, April 1st, 2023, May 1st, 2023, June 1st of 2023, July 1st of 2023, and August 1st of 2023. Giving you credit, Mr. Navarez. After credit, that totals to an amount of $9,660 in retroactive child support. The court also finds that you're in violation of the court order and failing to pay medical support on December 1st, 2022, January 1st, 2023, February 1st of 2023, March 1st, 2023, April 1st, 2023, May 1st, 2023, June 1st, 2023, July 1st, 2023, August 1st of 2023. I don't believe I said what the amount was in child support. You're obligated to pay $1,240. In regards to the medical support, you're ordered to pay $82 per month, giving you credit for the $120 payment that was on the motion for enforcement. I just moved it from child support to medical support. That would make a judgment of $618. So the court finds that you're in arrears of $9,660 in child support and $618 in back medical support. Those are the judgments of the court. You are to pay out the retroactive child support that you owe at $150 per month, and the medical support payments at $50 per month. The totals of the judgments are as of August 31st of 2023. The court is also going to have you make a lump sum payment of $1,000. You said you start that job in 2 weeks, right?
Yes, ma'am.
Okay, so the court is going to order you make a lump sum payment to the mother no later than December 29th of 2023.
Okay.
And you can make that either by Zelle, how you've been doing it, or you can do it by cashier's check. You can break it up in payments, however you have to do it, but it needs to be paid to her no later than December 29th of 2023.
Yes, ma'am.
The court is also, because you are found in contempt for violating the court order, you're also going to be ordered to pay attorney's fees in the amount of $1,500. The court is going to order that you be placed in jail for a period of 45 days total. However, the court is going to suspend that sentence and place you on community supervision for a period of 1 year. This will give you an opportunity to catch up with those payments, okay? There is a community supervision officer here present, and I will get your contact information, and you will have to be in contact with him. You'll have to report. However you have to report, that's what you need to do. Whatever the directives of the probation officer, you need to make sure that you follow that. It's not going to be an excuse that I didn't have the money, I couldn't pay, whatever the case may be. Just as you have bills and everything that you need to pay for, your child also has needs too.
Oh,
So
yeah, I understand.
I just want to make that clear, because if she comes back on another motion for enforcement and you're already under community supervision and you have failed to pay child support, the court has no problem placing you in jail for 45 days, okay?
Yes, ma'am. Yes,
Do
Your
you
Honor.
have any questions about that?
No, Your Honor.
All right, do you have any questions before I conclude the hearing?
Is it possible, am I going to get the 10-digit PIN, or is that not? So that I can make the payments through the Attorney General?
Well,
Oh, excuse me.
and about that, because you mentioned not having the money to pay the amount, it's not going to do you any good if the income withholding order and you're not making, they're going to pull whatever they can, but you're still obligated for the rest, right? So the Attorney General's office can only pull so much of your income, but if that is still coming up short, you're still responsible for getting that money to mom. But I do believe that putting an income withholding order would alleviate some of these issues.
Oh, okay, so that's in the future once I start working, and then that's the next step, basically.
Yes, well, Attorney Lay could do an income withholding order right now. The only thing is it'll just be sitting there until you actually start working. So you're also ordered, when you start working that job, she needs all of your employer's information.
Okay.
Okay.
Yes, ma'am.
So I'm going to conclude the live stream now. So we'll go offline, and I'm going to have you give your contact information to the probation officer that's here, okay?
Yeah.
Oops. Forgot to add it to the stage. Oops. Well, that's it for today, everybody. Hopefully tomorrow we'll be back on the old channel. It's just taking a long time. I'm doing a live stream. I'm trying to upload files and download stuff. It's going to take a while, but we're going to get back to the old channel. I thought it was a good idea, but then I changed my mind when I noticed this. I don't understand why I couldn't keep the content on that channel. Because I see other channels doing the same thing. They talk about stuff that's not their normal content. It's new content. And that's what I'm doing with Panorama Computer Services. I'm doing new content because I retired from technology. And we will be getting back to the old channel. If it takes me, it shouldn't take me but a few hours to get everything uploaded and downloaded. So until then, I will see you guys tomorrow at 3:00 p.m. Central Daylight Time. You all have a wonderful evening. Ta-ta, ciao, ciao. And I will see you again soon.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right when I'm falling apart. You put me back together. You make it better. From the wires tangled up to the broken dreams. You know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright when I'm falling apart. You put me back together. Daniel, you make it better. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's over.